Bernard, dear prosecutor, dear Mrs. Bensouda, I'm very pleased to welcome you all to the inaugural lesson of PSIA class of 2022. The inaugural lesson is a long-standing tradition whereby each new PSIA class is addressed by and then has the chance to engage with an important public figure. This is why we are extremely honored, dear Mrs. Bensouda, to have the pleasure to welcoming you today to address our students. You were sworn in as prosecutor of the International Criminal Court in 2012, having previously served as ICC deputy prosecutor since 2004. You were the first woman to hold this position. Prior to joining the ICC, Mrs. Bensouda has been Attorney General and Minister of Justice in the Gambia, as well as Chief Legal Advisor of the President and Cabinet of the Republic. She is firmly committed to gender equality and has been part of an eminent group of the International Gender Champions since 2018. As engaged and curious students of international affairs, I have no doubt that you are aware that Prosecutor Bensouda and the ICC have been in the news these past weeks. You will also know that the international community has responded with its clear support at the court official and prosecutorial independence and its important work. So today's lecture is truly an exceptional opportunity, perfectly timed, at least from a PSIA student perspective, to hear from and ask questions to Prosecutor Bensouda. Before I give the floor to our guest speaker, I would like to introduce and thank Antoine Bernard, who will moderate the discussion. Antoine Bernard is a faculty member since PSIA was established 10 years ago. He teaches on the role of NGOs and human rights protection and strategic litigation for international crimes. A renewed expert and practitioner on human rights and international justice. Currently serves as senior advisor at Reporters Without Borders and senior fellow, the Institute on Advanced Judicial Studies. Without any further ado, I'm very pleased to give the floor to Fatou Bensouda. Now a small and very short jingle, and then Fatou Bensouda, the floor is yours.
Dean Enrico Letta, dear Antoine Bernard, distinguished members of faculty and staff of the university, dear students and all participants who are following this lecture. I'm grateful for this invitation, and I thank you for your interest and thank you for your time. It is a great honor for me to deliver this inaugural lecture for the forthcoming master's program at the preeminent Sciences Po Paris School of International Affairs. And it is unfortunate that our exchange is not in person due to the ongoing challenges presented by the COVID-19 pandemic. It would have indeed been a great honor to be with you in person at La Perniche. But be that as it may, I'm delighted to do so virtually. After all, this has nowadays become the new normal. From the outset, I would like to extend my profound gratitude to the Dean of the Paris School on International Affairs, Professor Enrico Letta, for making this event possible today. It is a privilege to be able to share a platform with such a distinguished figure and to share a few words with you at a critical juncture in the state of multilateralism in which we find ourselves. And I would like to thank also Antoine for extending his gracious invitation and for moderating today's Q&A. Merci beaucoup, Bernard, Antoine. I look forward to our exchange. And it is a privilege to share with your generation as students and as future role models in international affairs, my views on multilateralism under duress, and present the case for international criminal justice and the international rule of law in this context. The international system, as we know it, is under great stress for a variety of reasons. The COVID-19 pandemic has added its own stresses on the system. As a global challenge, the pandemic has affected us all, our countries, our institutions, and citizens. And apart from the strain on economies, health, and education systems, and what we usually take for granted, countless lives have been lost. And I would be remiss if I did not convey my heartfelt condolences for all lost lives and my sincere empathy for the distress the situation has caused and continue to cause across the globe. The challenges posed by the pandemic and the international response to it have clearly demonstrated the need for multilateral cooperation between states to address matters of global concern. By showing efforts, and while not bereft of ongoing difficulties, the world has shown resilience towards the pandemic. As the Secretary General of the United Nations, Antonio Guterres, has poignantly stressed, none of us is safe until we all are. As the prosecutor of the International Criminal Court, I can attest to this statement. It resonates strongly with the opening words of the Rome Statute establishing the ICC, saying that all peoples are united by common bonds. Their cultures piece together in a shared heritage, and this delicate mosaic may be shattered at any time. As I deliver these remarks before you today, I would not say that multilateralism is in decline, but can safely say that it is under great stress. I observe with concern that in this new century, we increasingly find ourselves confronted with threats to multilateralism and the post-World War II rules-based global order, where the sanctity of sovereignty is misappropriated in the service of exceptionalism and a rejection of international law and international rule of law. A Hobbesian world where every nation must fend for itself in a lawless state of chaos will indeed be nasty and brutish. And this is not a theoretical construct, but the reality of the human experience and the lesson of history and of war and peace throughout the ages. Lessons on which the post-World War II global order, however imperfect, was built in the hopes of saving future generations from the scourge of destructive great power rivalry, perpetual wars, and mass atrocities. And the same lessons that gave birth to the world's most successful regional integration project to date, the European Union, inspiring many others to follow suit. But lest we forget that multilateralism as the preferred modus operandi for international state relations and cooperation, multilateral institutions, including those that advance the peace settlement of dispute and the rule of law, are all hard earned fruits of our costly experience, our common loss, and indeed, our common awakening and wisdom. In an increasingly interdependent world, faced with global challenges from climate change and cross-border terrorism to war and mass atrocities, real success and progress depends on our willingness to acknowledge that it is only through collaboration and concerted effort that we can hope to counter the destructive and destabilizing force of these ills. A zero-sum unilateral approach may result in a short-term gain, but is sure to issue in long-term net loss. In the wake of the Second World War, it became clear that international anarchy and the coercion and influence of competing powers could not continue unchecked without catastrophic effect. The only alternative we had to come to accept was a strong commitment to multilateralism and the development of a rule-based global order dedicated to mutual respect between nations and the maintenance of international peace and security. The United Nations was hence established, indeed, as it has been said, not to bring us to heaven, but to save us from hell. And from a macro level bird's eye view, the world is a less chaotic and safer place because of that innovation. That system, as we know it, is increasingly being challenged by potent forces. The setbacks we are currently witnessing are, however, not inevitable, and there are many countercurrents. Of note is the example and leadership shown by initiatives such as the Alliance for Multilateralism under the auspices of the Ministers of Foreign Affairs of France and Germany, which aims to unite states that espouse international cooperation and subscribing to the basic principles of the United Nations Charter, as well as international law and justice. Dear students, ladies and gentlemen, in the current political context, where multilateralism is under such duress, how about the case of international criminal justice, as represented by the International Criminal Court and the wider system established by the Rome Statute, which founded the ICC? After all, the court was not established in a vacuum, and nor does it today operate in a vacuum. It is often said that if someone would have the idea to create a court today, in the current state of the world in disarray, they would never succeed. Perhaps, but I posit that the creation of the court must be one of humanity's proudest moments. And I say this not as a partisan, but as a person who brings her mind to what the ICC is all about. What are the values and the goals of the Rome Statute, and what it means in the broader global context? For me, the ICC is a central pillar of a rule-based international system rooted in respect for international law and the fight against impunity for the world's gravest crimes of concern to the international community. Over 120 states across the world created the International Criminal Court as an independent judicial institution, complementary to national jurisdictions with the mandate to investigate and prosecute genocide, crimes against humanity, war crimes, and the crime of aggression. With the creation of the International Criminal Court, an important normative, but also a structural and system-based message was sent globally. That first, the commission of mass atrocities as merely politics by other means will no longer receive a pass, and that perpetrators, irrespective of rank or official status, must answer for their crimes. It also said that an international criminal justice system is crucial to a rule-based global order, and its institutional manifestation in the form of the ICC is now a reality and an important part and parcel of the global system. Today, the court benefits from the membership of 123 states parties and has possibly greater reach due to the court's jurisdictional competence. Since its start of the operations in 2003, with ups and downs and notwithstanding significant challenges, the court has managed to establish itself as a crucial judicial institution, gradually building its policies, its protocols, caseload, and its jurisprudence. The court has been implementing its mandate with full independence and impartiality, while benefiting from the judicial and operational assistance of its states parties, who provide cooperation in the context of investigations and prosecutions, including to grant investigators access to sites or to military or other records, to assist the court and the protection of witnesses, or to ensure the arrest and surrender of persons that are sought by the court. And as we speak, the office is busy with ongoing preliminary examinations in 9 situations across the globe to determine, in accordance with the strict legal criteria of the Rome Statute, if investigations should be initiated. And these criteria take into account the court's complementary nature, meaning that it will defer to domestic proceedings where possible. The preliminary examinations we are currently conducting include the situations in the Philippines, in Ukraine, and Venezuela. It also includes the situation in Palestine, in relation to which we are currently awaiting a decision from the judges of the pretrial chamber regarding the scope of the court's territorial jurisdiction in that situation, following a request that I made, my office made, in this regard last December. We are in parallel conducting active investigations, which means collecting evidence in order to establish persons most responsible for the commission of the crimes alleged. We are doing that in 9 situations, including in Mali, the Central African Republic, Libya, Darfur, Sudan, and Georgia. In Afghanistan, we are currently carefully assessing the documentation received from the government of Afghanistan in support of our request to the office, to defer to its national investigations. And I wish to emphasize here that my office conducts its activities consistently with utmost professionalism, independence, and impartiality, guided solely by its legal mandate as stipulated in the Rome Statute and the information and the evidence that emerges from its preliminary examination and investigation activities. For me, this is critical to the credibility and longevity of an institution as important as the ICC, not least given the political environment in which our cases operate. By its very nature, the courts frequently operates in fragile post-conflict situations during ongoing hostilities or against the backdrop of ongoing peace negotiations. Political stakes are usually high, and the prospects of an investigation and prosecution by the ICC is also viewed through such prisms. It is therefore no surprise that when we became involved in a given situation following our strict legal mandate, we are erroneously accused of being political in our actions. Yet nothing could be farther from the truth, as the track record of my office in particular demonstrates. I have and will continue to fulfill honorably and professionally my prosecutorial duties as mandated by the Rome Statute without fear or favor. The fact is amply evidenced in the way we have and continue to discharge our mandate. And this in fact is perhaps also the reason for the pushback and the resistance that the court is currently facing. But this is the nature of the beast. The court does not do popularity contests. It does crucial work to fight impunity for the world's gravest crimes, and hopefully, through this work, deter the commission of future crimes. As I often say, no single advance in human progress has traveled the path of least resistance. International criminal justice is necessary if we are to have a less conflict-prone world or at least ensure that the law does not remain silent during otherwise lawless wars, that the victims of atrocity crimes are not forgotten, that they too have a voice, that they too count and have access to justice for the atrocities that have devastated their lives and their livelihoods. International criminal justice has demonstrated that it works and can work even more robustly for the benefit of humanity's progress if it is increasingly accepted and supported by states as perhaps uncomfortable but necessary mechanism in the fight against impunity for atrocity crimes. Today, the dedication to my mandate and the law has come at a personal cost. Following the imposition by the US authorities of economic sanctions against myself and a senior staff member of my office. Other coercive measures have been taken and more are promised. And these coercive measures, these acts, they followed a series of prior threats and pressure by the US administration for the court to abandon a certain course of work, notably in relation to the situations in Afghanistan and in Palestine. As an independent and impartial judicial institution, we regret deeply the threats and the sanctions made against the court and its officials. But we remain fully committed to the mandate that states parties have entrusted to us. In the face of such unprecedented challenges, we have been very much encouraged by the chorus of support from all sectors of the international community, and no amount of threats will deter us from legitimately, independently, and impartially meeting our obligations under the Rome Statute. Dear students, ladies and gentlemen, this current tense global climate is nothing new, unfortunately. In fact, the adoption of the Rome Statute and the creation of the court in 1998 came on the back of some of the worst atrocities of modern history, from World War II to Rwanda and the former Yugoslavia. This was an achievement of all states that joined the negotiations, but in particular, small and middle-sized states. It was their relentless effort, often supported by the strong support of civil society actors like Antoine here and the organization he represented, among many others, that the long-time dream of a permanent international criminal court became a reality. Should we accept that the court, as created by the Rome Statute in 1998, is a child of its own time? The period after the fall of the Berlin Wall, when everything seemed possible? Should we put aside the good and the noble intentions of the founding states and the decades-long dreams of a permanent international criminal court that holds ultimately individuals into account for serious international crimes? Should we rather give away under the pressures of political might and expediency, which favor short-term political interest at the cost of the collective good? It will not surprise you to hear that my answer to all these questions is a resolute no. We should not abandon the millions of victims, whether past or present. We must stand firmly, ready to follow this road ahead of us, however long and challenging. Allow me here to refer to a situation to demonstrate my point, notably the situation of Darfur, Sudan, where the office opened investigations in 2005. At the time, the then President Omar al-Bashir, his regime refused to cooperate with my office. Neither were my investigators allowed to set foot in Sudan. This, despite the situation being referred by the ICC, by the UN Security Council, they refused to cooperate. But notwithstanding these challenges, every effort continued to be exerted by my office to collect evidence and strengthen our cases, even while warrants of arrest issued by the court have remained outstanding for a considerable number of years. While initially the court received substantial support from the international community, including in the African continent for its work, it soon became a major bone of contention, notably for the fact that Mr. al-Bashir was a sitting head of state, notwithstanding the irrelevance of official capacity under the Rome Statute. However, since the removal from power of former President Mr. al-Bashir on the 11th of April 2019, Sudan has undergone an extraordinary political transition. Despite the volatile situation on the ground, we were able to successfully achieve the surrender and transfer to the court of one of the suspects in the Darfur situation. On the 9th of June 2020, Ali Mohammed Ali Abdel Rahman was brought into the custody of the ICC. Mr. Ali Abdel Rahman is suspected of war crimes and crimes against humanity allegedly committed in Darfur. And just recently, a peace deal was signed between the transitional government and most rebel groups with the hopeful signs that Mr. al-Bashir would also face accountability and possibly before the ICC in due course. This is an important milestone as various parties endeavor to find workable solutions to find lasting peace for Sudan. But this example indicates that patience and perseverance and reliance on legal facts over political ad hoc decision-making are a necessary element to ensure that the global rule-based order can continue to work and contribute to the multilateral system in a way that it is supposed to. From its supporters, the states parties and other actors, what is needed is sustained cooperation and support for the court in the pursuit of justice. Ladies and gentlemen, it takes the courage and often the sacrifice of millions to finally adopt multilateral institutions that advance the human condition and experience. But only silence and inaction in the face of ill wishes to lose the progress that has been made. Where mass crimes are tolerated with impunity, where justice is silent, and where the truth is unheard, we make it possible for evil to triumph. And ultimately, international criminal justice with the ICC at its core serves humanity as a whole. It is not exclusive to one people or to one place or to any time, one time. Its protective embrace is for all to enjoy, so long as we have the courage to join it, stand firmly by it, and help withstand its challenges. I would like to recall here the sage words of the late Dag Hammarskjöld, the second Secretary General of the United Nations, where he stated that it appears, and I quote him, on the basis of daily experience, that the world of order and justice for which we are striving will never be ours unless we are willing to give it the broadest and the firmest possible foundation in law. That is the end of his quote. I can only echo this very crucial sentiment. What is required today, and more than ever, is greater support for the ICC, its independent and impartial work, and the international rule of law, and not less. Any act that may undermine the global movement towards greater accountability for atrocity crimes and a rule-based international order must be avoided. The stakes could not be much higher, and this is very much a defining moment for the court, for the Rome Statute system, and for the credibility of the Rome Statute system. The response from the states parties and other stakeholders is a real test for the multilateralism, international criminal justice system as part of the global order. And this response will determine in many ways how the Rome Statute system will shape up for the foreseeable future. Will we all pass the test? It's a question. Will we all pass the test? Time will tell. I'm nearing the end of my term as prosecutor of the International Criminal Court, which will conclude in 2021. A new prosecutor will be appointed this December and begin work next summer. And I hope that my successor, whoever that may be, will equally pay homage to the Rome Statute as we have done, with utmost integrity and professionalism, led by our sense of unflinching responsibility towards our mandate, solely by the dictates of the Rome Statute. While there are still far too many conflicts around the world where mass atrocities are being committed during my tenure, I have done everything in my power to ensure that as many victims as possible will have their voices heard and be able to reap the benefits of justice. We are not perfect, but as an office, we have strived to learn and improve continuously, adjusting our policies and strategies where this is needed. Sciences Po is one of the world's most prestigious institutions of higher learning. The knowledge and expertise you will acquire during your studies at the Paris School of International Affairs will undoubtedly assist you to become the next generations of political advisors, public servants, analysts, researchers, diplomats, consultants, international jurists, and beyond. What you do with that knowledge will be crucial for the success of multilateralism and international organizations such as the ICC. We need more global actors who can understand and respond to the complexities of our world and to be forces of good for the world. Even if now under strain, multilateralism has to be the preferred modus operandi for interstate relations and cooperation to advance the peaceful settlement of disputes, and in the case of international criminal justice, accountability and justice to the victims. The future awaits to embrace you, to embrace your ideas and your achievements. At a time when negative forces aim to divide our societies, I have complete faith in the new generation, in talented young students like you in this room, who will carry the torch of enlightenment, the torch of tolerance and progress as you enter a new promising chapter of your lives. Here is hoping that with unshakable resolve, advocates and agents of peace and stability the world over in this and future generations commit to ensuring that multilateralism, the international rule of law, and their instruments of practice take humanity to the next aeon of civilization. The challenges are formidable, but so are the costs of failure. I thank you all for your attention, and I look forward to our exchange in the question and answer session. Thank you.
Thank you very much, Madam Prosecutor, for this very inspiring lecture.